All right. So if we do have the agreement that there are two political statuses in this country, you're either free or you're a slave, serf. All right. Then therefore, and you're back here because you want to find out how you could volunteer out of that system. Well, it would probably take some foundation, wouldn't it? Wouldn't it take some foundational questions to be answered first before we even get to that? Because I'll give you a background here. I mean, when I first came across this information as a non-lawyer's perspective, I just jumped right into it. And I thought, I'm going to go to court and I'm going to win with this. And I got laughed out of the court. I got handed to me. I went everything wrong. I lost. I mean, it was just humiliating going to court with this stuff. So this is not about going to court. That's not what this procedure here is about. This is about a foundational understanding of of what law system that we're under regarding the political statuses and where it comes from and what we can do about it to decide what political status that we are as individuals. So if we go back in history, and we really look at the where our background and history comes from, it's backed up in cases. But I'm going to go back, before I go way back in time. I want to start with the 14th Amendment era, where there was a major change within this country. Now, if we look at the 14th Amendment, now I've got a paper here that I've written up, and it's going to give a little background on this, but I want to make the case that Lincoln's motivation, okay, for the Civil War was not about slavery. It was about state secession. This is a very, very important point. And it all ties in to this whole political status thing. All right. And but I want to give you the background and the foundation. So there would have been no war and no Reconstruction had Lincoln not invaded the southern states. His reason for doing so was not to free and improve the conditions of African American populations, as many Americans deeply need to believe, but Lincoln's state of Illinois prohibited free blacks from entering the state or allowing blacks to testify. Lincoln never opposed these black codes, and he even introduced a bill in the legislature when he was at the state level to remove the entire black population from the state. Immediately after his election, Lincoln supported the Crowell Amendment, a proposed 13th Amendment to prevent secession in 1861. This would have made it impossible for the federal government to interfere with slavery in the states. Lincoln never spoke publicly against slavery. Never. The only thing he ever spoke publicly about was stating that secession was the reason the war was necessary, was secession was unconstitutional. The South was outraged by Lincoln's election. In response and secessionists implanted plans to leave the Union before he took office in 1861. 6 of the states declared themselves to be sovereign nations. Confederate States of America had adopted a constitution. So Lincoln's justification for the invasion, the only reason he ever gave to justify the invasion was that secession is unconstitutional. How could anyone in the land of the Declaration of Independence think that secession is unconstitutional or illegal? I mean, if the states are sovereign, the debate around sovereignty, if the states are sovereign and the central government is the creature of the state, then Lincoln and others believe that the states were never sovereign political society. They believe that the sovereignty resides, they say, in the American people and the mass as individuals whose sovereign will is expressed in the central government, which authorized the formation of the states. So in this view, the states are creations of the central government, and as such cannot secede from the Union any more than a country could secede from the state. Lincoln himself compared the states to counties. So a small county government, that's what he can compare the states to, not to sovereign nations. This is a very, very important point when we're gonna break down and give you the foundation as to why this 14th Amendment came to be and what we can do about it. So if we could, how can we decide on this theory? If Article 2 of the Articles of Confederation states that each state retains its freedom, independence, and sovereignty, that's what it says in the Articles of Confederation, Article 2. Did the states lose their sovereignty? They can't, because under international law, sovereignty can't be lost without express renunciation. So what happened to it? If the states are sovereign political societies, then they can secede. So citizenship and allegiance under the 14th Amendment. After the passing of the 14th Amendment, the Supreme Court's landmark decision, Wong Kim Ark of 1898, determined that the U.S. citizen owed protection for allegiance because it brought forward the old English common law principles. And I'm going to show you where this is in this case, because everything I'm talking about here is backed up in Supreme Court case law. This is not just some nonsense. And if you don't have authority from the Supreme Court, you might as well just raise a big question mark to anything you're reading, because somebody needs to point out where it was in the law and where the Supreme Court has highlighted these provisions. And that's what I'm going to do for you. So the Wong Kim Ark Court found that the Constitution nowhere defined the meaning of words either by the way of inclusion or exclusion, except as so far as to be done by affirmative declaration by all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. So in this and other respects, it is fairly interpreted in the light of the common law that the principles in history are of which were fairly known by the framers. So the fundamental principle of the common law regarded to English nationality was, this is a quote from the case, within the allegiance, also called legality or obedience, faith or power of the king, citing Wong Kim Ark. Also citing Wong Kim Ark, allegiance and protection in this connection, that is in relation to citizenship, are reciprocal obligations. The one is compensation for the other, allegiance for protection, protection for allegiance. I owe allegiance to the United States. The United States gives me protection. That's what it's stating. Now, according to Mr. Fish, this is also from Wong Kim Ark. This is Mr. Fish was like he was head of one of the administrative agencies at the time under the president, and the president asked him for an opinion. He says, in the opinion of the court, which his opinion, the court gave a lot of weight to, much weight in the Wong Kim Ark, it states that the states are sovereign. And if so, then according to the Immigration and Nationality Act of 1952, the terms state, lowercase s, in section 21, quotes, the term national means a person owing allegiance to a lowercase state, would mean that it could be one of the sovereign 50 states. This is the big hang up that I had on this for years. For me personally, I'm a Yankee, I'm from the North. Okay. That's my heritage. So I can't imagine. I never was under the belief that the states were sovereign. That was not how I was educated. That's how Lincoln and the North taught. The states aren't sovereign. They can't secede. The South is the enemy. And being from that background, when I read this section of the Immigration and Nationality Act, which says that lowercase s means a national, means a person owing allegiance to a state, that only could mean a foreign country to me. So I kept thinking that, well, this is absolutely irrelevant to the states of the Union, because the states aren't sovereign. They can't be sovereign. That was my prior thinking. But accordingly to the Wong Kim Ark decision, the Supreme Court brought forward the old English common law principles under England as applies to the 14th Amendment citizens of the United States. And those principles being those of the feudal system. I'll show you this in the law. Feudalism, according to Webster in 1913, is the feudal system, a system by which the holding of estates in land is made dependent upon an obligation to rendering military service to the king or feudal superior. Now, the implications of this Wong Kim Ark decision and the U.S. citizenship as a feudal allegiance. Here's the conclusion. So accordingly, if pursuant to Wong Kim Ark, the Supreme Court case brought forward the old English common law principles under England as applied to the 14th Amendment citizens of the United States, those principles being those of the feudal law, the feudal system, allegiance for protection, protection for allegiance, Feudalism, according to 1913 Webster's, is a feudal system, a system by which holding of estates and land is made dependent upon an obligation and rendering military service to the king, a feudal superior. Therefore, a U.S. citizen has pledged his allegiance for protection, just as in feudalism, where the serfs pledged servitude to the lords of the manor for protection. Because feudalism is a form of voluntary servitude, which is legal under the Constitution, because what? The 14th Amendment, the 13th Amendment, these outlawed involuntary servitude. But voluntary servitude is completely legal. Anyone who volunteered in generationally to become a U.S. citizen, serf, even if by presumption, couldn't they just volunteer out under Public Law 94-241? And pause